think we're ready to start. We have a great panel. It's being moderated by Tom Paul, and I told Tom I would have to introduce him. Tom was a highly regarded manager at the Federal Trade Commission for years. He was an advisor to Commissioner Asquinaga, and has practiced in the area of financial practices for years. He is now at the CFPB. Some of our great attorneys have moved over when the agency was created, where he is managing counsel. So Tom, please take it away.
Thank you, Tom. Yes, I'm a managing counsel in the Office of Regulations at the CFPB, where a lot of what I work on involve debt collection and credit reporting issues, including rulemaking and policy work. And so I've been very interested in what we heard this morning, and I'm very looking forward to what we're going to hear this afternoon as well. You know, our first panel today really discussed the aspects of debt collection that occur before consumers end up getting into the court system. And we're going to take the next step here on this panel and talk about the experiences of Latino and limited English proficiency consumers once they get into the debt collection litigation process, and really trying to figure out whether or not there is fair access and fair treatment for members of those communities in the court systems, and if there are problems, what kind of solutions might be worth considering as we move forward to correct those problems. Fortunately, we have a very experienced and esteemed panel that's going to help us walk through these issues this afternoon. The panelists, I will give them an opportunity now to introduce themselves, and we can start with Jose, who is immediately to my left.
Good afternoon, everyone. My name is Jose Alarcon. I'm a staff attorney at Bedzedek Legal Services in Los Angeles. We provide free legal services to low-income individuals. I manage the debtors' rights and bankruptcy program, and what I do, I work mostly with seniors and individuals who are disabled. I do a lot of educational workshops to provide them with information about how debt collection works, what to expect if they're facing a lawsuit, and what happens after a judgment's entered. And we also assist in other types of issues, identity theft, student loans, a little bit of tax matters as well.
Good afternoon. My name is Joseph Jaramillo from Housing and Economic Rights Advocates. I'm a senior attorney there, and HERA for short. And what HERA does is we protect consumers and low to moderate income homeowners and people against discriminatory and abusive practices in the realm of financial products, particularly for homeowners and people that are in danger of losing their homes, but also for students with student loan debt and other types of debt collection, and also trying to provide access for credit.
I'm Ted Merman. I'm the executive director of the Public Good Law Center in Berkeley, California, but I think I'm actually here in my role with the East Bay Community Law Center, also in Berkeley and Oakland, which has a consumer law practice, a debt collection defense practice, and recently launched what we think, although anyone here can correct me, is the first immigrant consumer law clinic in the nation. We were co-sponsor with the California Attorney General's Office of SB 233, the Fair Debt Buying Practices Act.
Good afternoon, I'm Michaela Moody. I'm general counsel for Wakefield & Associates, which is based out of Aurora, Colorado. During the course of my career, prior to becoming in-house counsel for Wakefield, which is an accounts receivable company, I served as outside counsel and litigated on various levels for creditor rights during the course of my career. And thanks for having me today.
Good afternoon. My name is Harvey Moore. I'm the president of the Moore Law Group, a debt collection law firm with offices in California, Colorado, and New Mexico. I am currently standing for president-elect of the National Association of Retail Collection Attorneys, and tomorrow morning at about 10 o'clock I will be giving my speech at the NARCA conference. I am the current education pillar chair. I have been the NARCA Professional Standards pillar chair, have chaired the NARCA Amicus Brief Committee, Law and Legislation Committee, Task Force on Debtor and Consolidator Scams and Fraud, and I'm also a past president of the California Creditors Bar Association.
Great, thank you everyone. As with our earlier panel, we will try to save some time at the end to pose questions from the audience. And so I'd encourage everyone who has questions to write them out on the note cards that are found on the seats, and people will be collecting them in the aisles and bringing them up here for us to pose. And one thing I did also want to point out is that, even if we don't get an opportunity to pose your questions, they are important to us, and both agencies will take them back and consider them and are thinking about what we hear today, because we realize that as much as we'd like to be able to pose all of the questions, we may not get to them for reasons of time. Well, without further ado, I think one of the things that would be very useful to start with is to make the transition from the last panel and ask Michaela and Harvey, basically when a debt goes from being in the pre-litigation collection channel and is being switched to the litigation channel, what do debt collection attorneys at that point know about whether the consumer is a Latino or is a LEP consumers, and what effect, if any, does that have on how they approach the collection of the debt?
You want to go first?
Generally, when I get the information for a collection litigation in particular, I have very limited information concerning whether or not a particular individual is limited English proficiency or not. It's usually after the court case has been filed and I have the initial communication with the consumer inside the courthouse that I learn that oftentimes.
So we have a somewhat different situation. Our client base is primarily original credit grantors. When we are seeing a trend that as files are now being placed with us, the clients are working on advising us that the language of the contract or the language of the initial communication between the credit grantor and the consumer was Spanish language. So we're starting to see more of an information flow coming from our clients. The primary way of finding out, though, if somebody is a LEP Latino is through the initial communication that we get either on an inbound call or an outbound call, and we find out that the consumer is a Spanish-speaking consumer, and then we would carry on communication with that consumer. One thing that we try to take into account in our firm, and I think this is standard in the industry, or at least standard for the NARCA members, is we are subject to fair lending. And we have a policy and procedure in our firm that we follow, and that is that when dealing with a consumer in any phase of collections and litigation, we cannot discriminate against a consumer based upon race, color, religion, national origin, sex, marital status, age, or their good faith exercise of rights, familial status, or handicap. So the fact that someone is an LEP Latino or a Spanish speaker doesn't get them treated differently per se as far as how we treat them for the ultimate resolution, which is to try to make them or try to have them become a payer if they are the person that is obligated on a legitimate debt owing to one of our clients.
All right, thank you. When debt collection complaints are filed in court, consumers often don't defend, which leads to default judgments against them. In 2010, the FTC issued a report in which it estimated that roughly 75 to 90% of debt collection cases that are brought against consumers end up being not defended and becoming a default judgment against consumers. One thing I'd be interested in hearing from members of the panel is whether the failure to defend and default judgments is something that occurs in a similar prevalence with Latino and LEP consumers or not? And if so, is there anything that the panel members think should be done that could encourage these consumers to defend the cases and avoid default judgments being entered against them? And I guess I'll throw it out to all of the panel members who'd like to comment on that.
I would say what I've seen somewhat unique for the Latino community, what I've seen is a lot of clients who've gone to individuals who are not attorneys, paralegals, notarios, or other individuals for help. Many times they pay for the answer, And for whatever reason, I've seen it more often where they don't bother to file the answer, or they don't take that final step of actually filing the answer. Recently this week, I had an attorney, a colleague of mine, who came to me with a case like that, and that particular client did exactly that. He went to someone, not an attorney, paid for the answer, but did not file the answer because he had heard there was a fee for the answer, to file the answer, and didn't know about the fee waiver. I think that's one reason. I think the other reason, a lot of clients, Latino in particular, are fearful of the court system for various reasons, and they feel that they have to take action. And just going to someone for help and filing the answer, they get some relief, but actually taking that step, that fear and the stigma related to it is one reason that they don't go forward, regardless of whether or not they have any defenses.
We've had a similar experience in terms of Latino clients and immigrant clients and non-English or limited English proficient speaking clients. There's a lot of them are intimidated to go to the court system or trust the court system. Many of them do not know their rights, and so by the time it gets to us, maybe 10 or 20 people have been scammed, and then finally someone comes to seek legal assistance. We had one case where there was a gentleman who was a real estate agent promising to save people from foreclosures, charging money up front, which is illegal, and then whether or not he got the foreclosure stopped and got a loan modification for the client, he would demand that they pay even more money, and when they didn't, he would sue them. And he's not an attorney, so he would just go into court and sue them pro se. When the client came to us, we basically searched a couple of the court systems in the Bay Area, and we found that he had sued over 20 people using the same pattern. So we reached out to some of those people, and we happened to contact an attorney who had defended some of those people when the same person sued him again and was able to help them file answers. And we talked to them, and a lot of it was intimidation. And I think in this particular instance, and this may be, maybe a common pattern with notarios or non-attorneys who are offering foreclosure rescue or other types of financial assistance, they felt intimidated by the person himself because he's a real estate agent. He's educated, in their minds. He knows the court system, and they just didn't want to stand up to him. So, and there's been other cases where debt collectors have gone after non-recoverable debt, like a first lien mortgage after the foreclosure happened, and they bought the debt from the lender, and then they sued to recover the remaining balance on the debt, and that's non-recoverable in California. We're a non-recourse state. And many of, by the time a client came to us with that problem, we were able to find out that over 100 people had been basically sued by this particular debt collector, Heritage Financial, and most of them either settled with them before, by paying some amount for the debt owed, or just basically let a default judgment be entered against them. So it's a big problem.
I would concur with both Joey and Joe. This is something that we've seen as a distinction between Latinos and other clients that we have. I want to just also say, though, to Tom's general point, the rate of default. I mean, the rate of default across the board is a matter of great concern. If the great majority of cases are going without the defendant ever showing up in court, there is no due process if you are not there. One of there are certainly different theories for why this was happening, and we've heard some of them from the consumer side, from the collector side or the debt buyer side in particular. It seemed as though there are at least some bad actors, presumably, who were using this as something of a business model, because if you were able to bring cases through the court system and get a judgment that would, as the previous panel mentioned, it would extend the statute of limitations. It would allow you to garnish wages. It would allow you to levy bank accounts, put liens on property, and so on. And you could collect it yourself, or you could sell the debt again at a higher rate. And what this occasioned, unfortunately, was a lot of abuses. Some of what we heard in terms of the names and the additional data, we had one client who was contacted, asked, she said, that's not my middle initial. What is your middle initial? This. What is your Social Security number? That. And then, of course, they call back, and now they have the Social Security number. Now they have the new middle initial. That is the sort of practice that we were seeing about, in particular, about 5 years ago. And that's when, I don't know exactly when the FTC's data was drawn from, but I think that really was quite prevalent certainly throughout the Bay Area, and from what we've heard throughout the state of California. I do want to say, in response to some of the things that Mark mentioned in the first panel, that we, at least in Alameda County, I can't speak for all counties, and in fact, I think I don't speak for all counties in California. I think there's a real variance. We have seen a real difference. A presumable default rate up around 90% is much closer to 20% now in the cases that we have seen. That's certainly an improvement from the industry side. We like to think it's also an improvement based on the anticipation of, and now the active existence of, the Fair Debt Buying Practices Act, which has provisions that work against this kind of accidental or intentional cases of mistaken identity. People were certainly willing to pay a certain amount to just make people go away, even if it's not the right person. And as many people in this room probably know, one of the co-authors of that act was a state senator named Luis Correa, whose wages were garnished because a different Luis Correa had a department store account that was being collected upon.
Well, I think it's a little bit different, and we have to recognize there's some semantics difference in the way that you're using the term default judgment. In Colorado, a lot of things get lumped in as being qualified as default judgments, and they're, for statistical purposes, considered to be default judgments. But what's happening is we have mandatory appearance jurisdictions, which mean on first appearances, and once they're served, they have a specific date and time that they have to come to court, if they choose to come to court, or a deadline for filing a response of pleading. Oftentimes we're seeing a lot of limited English proficient individuals coming into court, and they're acknowledging the indebtedness. They're acknowledging to the court that, yes, they owe this particular debt, and they just don't have the financial means or resources or ability to pay that, or they may just be simply uncollectible in certain situations. Those qualify as default judgments, but it's very different, because an acknowledgement, it's not that they're failing to defend. There's no point to defending. And I think that has to be considered when you're looking at the semantic difference, and that there are terms of art that are particularly useful within the court system that have connotations that sometimes the general populace doesn't always understand, whether it be limited English individuals or even people who speak English as a first language.
I want to follow up on that, because we have seen default rates go down, not necessarily because of answers being filed. There's been more bankruptcies, there's been more settlements. But one of the things you have to take into account when you consider a default judgment is a lot of consumers that owe legitimate debt to a credit grantor, or if the debt's been sold off to a debt buyer, acknowledge they owe the debt, as Michaela said, and I think they've come to the conclusion of, I don't want to spend the additional money. I don't want to pay a lawyer. I don't want to pay a filing fee, because in California the filing fee can be over $400 to file an answer in court on a case that's over $10,000 in debt being sought. So they're acknowledging to themselves they owe the debt, and filing an answer and going through the court system and spending the time and missing work takes time and value that I think a lot of the consumers that are sued today say, I'll let the judgment go. I'll let them take a judgment. If they can find my assets, then they can collect. If they can't find my assets, they have a judgment against me. It's sad but true, their credit has already been impacted because they have a debt that's gone into default. They've got a charge-off, be it an I-9 or an R-9. So I think a lot of people today take a look at a lawsuit and say, I know I owe the money, but I'm not going to invest the time or or the money to defend. And I think we see a lot of that.
Can I add something here? We're here today at a roundtable to discuss issues and how we can help the community. I think in regards to defaults, whether or not that's true, I think our role, at least my role as an attorney, as a legal aid attorney, is to make sure that my client has the choice to know whether or not to file an answer. And I think a lot of clients don't know that they have that choice, whether they feel they're compelled to file an answer or whether when they get served, they don't realize it's a lawsuit. And so I think us as advocates, our role is to make sure clients are aware of what the rules are, what their rights are, and then give them the choice to file an answer if they choose to. There may be reasons why they want to respond. Maybe they need time to negotiate because they've been trying to negotiate with the collector and the collector has refused to accept payments. I see that a lot. Clients say, why am I being sued? I've been calling them. I've been trying to send them payments and they won't accept it. Now I'm getting sued when I've been trying to pay off this debt. I mean, there are a lot of different reasons why people decide not to file an answer or to ignore the lawsuit, to get involved. Either way, I think our role as advocates is to make sure they know they have a choice and what that choice really means.
And one thing to take into account, in California, and I brought the summons with me, every complaint that's filed in California has what's called a summons, that is the front page that they see. And we're talking about LEP Latinos. The language on the summons in California is translated in Spanish, and there are two websites referenced on the summons. One is the California Courts Online Self-Help Center, and the other is a legal aid, a way to find legal aid. So it's translated into Spanish, and there is an opportunity for the LEP Latinos, when they are served, they can go online, they can go to the Self-Help Center, and they can also look for free legal assistance that they are directed to by the state of California, by the court system, on where to get help and where to get advice.
I guess one question, just a follow-up question. Is that something that consumers find understandable? I mean, even if they're Spanish-speaking consumers who read it, is that language in the summons clear enough so they know what their rights are?
I am not fluent in Spanish.
I'm not either,
But I
so
have,
we're probably
but I
not
have
the two
asked,
people.
I
that
have
say.
asked my staff members, because we do have collectors and litigation support staff that speak Spanish. I think it's clear. It's in the same type as what it is in English. It says, notice you have been sued. The court may decide against you without your being heard unless you respond within 30 days. Read the information below, and then the court website, by the way, is in Spanish. Mm-hmm. There are videos in Spanish available to the LEP Latino consumers. The Self-Help Center website is in Spanish. So there are tools available to the LEP Latinos, available when they are sued and when they receive the summons.
I want to go back to something that actually Harvey pointed out, and that is that, you know, many people that are sued go through the thought process of, how am I going to defend this? Can I defend it? Can I afford an attorney? Can I afford the time? For LEP Latinos, I think one of the issues is, you know, they don't necessarily know how to use the internet or have access to the internet. Many of my clients don't use email, so that's not going to help them. I think another issue is they may immediately, you know, or one of the big things weighing on their mind is, you know, can I afford an attorney? This is court. I can't go into court by myself, and I can't afford an attorney. And unfortunately, you know, many consumers don't know how to reach out to a nonprofit or a legal aid attorney. And maybe it's on the summons, but it's still intimidating for them. So that's one issue. And then just another thing I wanted to point out is, you know, we've seen people with default judgments who were never actually served. There's one method of service is substitute service, where you leave it with an adult at the last known address and then you mail a copy. Oftentimes, you know, the consumers moved on several times, several different locations, you know, before that service took place. So sometimes there's no notice and there's a default judgment that occurs as well.
Let me go one step further along the process after the summons. You know, obviously when litigation begins, there is a complaint and there maybe attachments to that complaint. And one question that I think would be helpful to hear from the panelists is whether Latinos and LEP consumers understand these court documents when they receive them, and if not, are there things that could be done differently to make those materials more understandable to them? And I guess Joseph or Harvey or anyone else who'd like to weigh in on that, please speak to it.
I mean,
I'll go first, and then I'll.
sure. I think it's something that should be looked at. I mean, one of the things is the California courts are looking at providing better language access throughout the whole system, and they're going through a language access planning process right now, and they've solicited input from stakeholders and the public as well as experts. And one of the things that they point out in the course of doing that is that it's not just being in court and not having an interpreter, because California does not provide the right to an interpreter in civil proceedings at this point. It's also everything else that goes around a legal process. There are court-ordered mediations, there are case management conferences, there's settlement conferences, and different things, different points in the process where people don't have access to really understand what's going on because they don't have a court-certified interpreter. They may have a family member who looks at it and tells them what it means, but family members are not trained, and they don't understand legal terms necessarily, and so there's going to be a lot of room for miscommunication there. And one of the things, one of the recommendations that came out of that report was that court orders be translated officially, court-certified translations of court orders into a language that the consumer can understand. And the summons is an interesting issue. I wonder, before I became a lawyer, I'd seen a summons before in English, and it just looked like, a bunch of words, and I tried to figure out, everything that it meant, but I can see how it just looks intimidating, and I think that's a form that maybe there could be something in more simple language, and just kind of highlight that you need to see an attorney, and there are free legal services available. I know it says that in some ways in the current form, but I think there are ways to make it look less intimidating and more simple to someone, so it could be more accessible.
So the question is, again, do they understand the language of the documents? And I agree. The California Judicial Branch just finished a strategic planning process for language access in the California courts. It's a very long document, but one of the things that it says, and I'd like to just read a quote from it, it says that language access must start before an LEP user reaches the courthouse doors. It must begin with community outreach and education efforts, web-based access, and the utilization of ethnic media access or outlets to educate the public. The starting point for the process is not when I serve somebody with a summons and complaint. The starting process has to be an educational process. The public needs to be educated about the legal process, about what happens if you get yourself in an economic problem, what happens if you get yourself sued. The process can't begin when the clock starts and you have 30 days to respond. It needs to be educating the community about the system, about what system you're living in, what your legal rights are. And I will say this, and I mean this, my filing a lawsuit to me is a failure on my part. I've been practicing law for 34 years. I started out as a business litigator. I did not start out as a debt collection attorney. Filing a lawsuit means I have failed in my job to negotiate a settlement prior to having to file a lawsuit. And my staff knows I believe that, and I think it's something that's ingrained in me. I don't want to spend the money to file the lawsuit. I don't want to spend the money to serve the consumer or go through the process to get a judgment. I would much rather have open communication with the consumer when I get that file placed, when I send out my 1692G letter, which says the file's been placed for me for collection. You have the certain rights to request validation, et cetera, et cetera. But what I really want is I want to enter into a negotiation agreement with a consumer about the repayment of a legitimate debt, a legitimate obligation owing to my client before I file the lawsuit.
I just want to echo and support what I'm hearing from both sides of me, that it is, that education, I don't think it's an either-or proposition. I think it should start in the community. There should be outreach. Telemundo is working down here. Univision has it. Consumidor al Día in Northern California. There are several media stars in this room who have appeared on that. I think that is that's an essential component. I think that Harvey wouldn't disagree that you also want the summons to be as clear as possible, and that you want the reaction of a person reading the summons to be understanding of what is going on as clearly as possible, knowing where what the next step is, where to go for resources. And we want ultimately education to be happening at every point in the process, for the materials to reflect that, and for people to be understanding what is going on, as well as being aware of what their rights are in the process. If there is vehement agreement on this panel, then I think it's a good thing.
Let me follow up on that by asking, what particular topics are most important for Latino and LAP consumers to learn about, and what could be done to bring that about? And maybe if Jose and then Michaela could speak to that, that'd be great.
Great. Well, what I do at BedZetic is we get a lot of calls for this type of assistance, individuals who are dealing with debt collection. And we have limited resources. We're a nonprofit, a legal aid office. So what I've done to sort of try to get out to the community is when someone calls us, we have them attend a presentation, a debtor's rights clinic, if you will. And at this presentation, I give an overview on what I think is important for the debtor to understand in regards to the law. I give an overview on the Fair Debt Collection rules. I give an overview now on thanks to Ted, the Fair Debt Buyers Practices Act, on how credit reports work and scams to be aware of. I talk to them about what issues to be aware of when they're dealing with credit counseling agencies and trying to set up a debt management plan, on what a lawsuit really means and the statute of limitations and discovery and getting a judgment and the exemptions involved with the judgment, enforcement actions. And then I talk to them about bankruptcy, Chapter 7, 13. I try to give all this information in 90 minutes, and I rely heavily on handouts, materials available from different government agencies, the FTC, the Consumer Financial Protection Bureau, Department of Consumer Affairs. Fortunately, a lot of this information now is in Spanish, so it makes my job a lot easier. So from my perspective, on my side of the table, clients, in order for them to really understand how collection works and where they fit in that process, they need to understand all these different areas of law. And it's difficult for a lot of individuals because it's a lot of information. After they attend the presentation, then we offer them a one-on-one consultation. Usually I found that individuals, when they come in, are not as scared, not as intimidated about the process, and are better able to understand the information I'm giving them at that point during the initial consultation. Okay.
Well, it's kind of an interesting thing. I'm not licensed to practice in California, and I don't practice in California, so I apologize to the rest of the panel since I'm not familiar with California in particular.
You know a lot more about Colorado than we do.
Well, Colorado's kind of interesting because we developed a language access plan that went into effect back in 2011. And under that language access plan, unlike California, what I'm hearing is that we provide, at the court's expense, interpreters, court-certified interpreters for every hearing and ancillary proceeding to a court action with the court-certified interpreters, regardless what type of claim it is or what kind of action it is. It's just general across the board. The other thing that Colorado did that's kind of interesting is for the fiscal year of 2013-2014, we have 22 judicial districts in the state. And part of the judiciary budget for that year provided for a self-help center in each individual judicial district. And those in the more densely populated areas have attorneys sometimes that staff that. They provide procedural information, they help with the forms, on our court's website, they provide most of the forms both in English and in Spanish. There are instructions for filling out those particular forms in English and in Spanish. And I'm going to correct one little thing I said earlier, is I said generally there's an appearance date. It does depend on which court you're in. If you're in our district court, that's anything over $15,000. It's a more traditional line where you get summons and you have to answer by pleading within 21 days. In our county courts, which is where the vast majority of our collection suits are being filed, that's a mandatory appearance. And the courts are putting those mandatory appearances because they want the parties to get together. And they want to have communications before it has to escalate. And if an answer needs to be filed, by all means, file an answer. The nice thing about our system with these self-help centers is because as an attorney that represents a party with an adverse interest, and we have to understand, the court process is an adversarial system no matter what. It's inherently designed to resolve disputes. And so I can't give legal advice to the other side. I can encourage them to seek legal counsel. I can tell them there are legal aid services out there, and I can direct them to the self-help centers that are available in each of the judicial districts to assist them with filling out the pleadings. And I mean, in Denver in particular, the nice factor is our self-help center is staffed not only by an attorney, but she's also bilingual and helps. And the court's interpreters are there to provide for the judicial districts that don't have a bilingual attorney on staff.
Thank you. I think that's a good segue to asking a question that involves representation by counsel, because of course that can be critical to protecting consumer rights in an adversarial system. Just ask the panelists, how frequently are Latino and LEP consumers represented by counsel in debt collection litigation, and who are these counsel? Are they from private firms, or are they from pro bono organizations, legal aid? And is there anything that could be done to encourage more representation of Latino and LEP consumers in debt collection litigation? Just to offer that to the panelists.
So the percentage of consumers that are represented by counsel in any debt collection case is a relatively small number. I don't track, and again, until this panel discussion and the topic came up, LEP Latino was not something that we were thinking about necessarily in connection with our practice. We do have bilingual collectors. We do discuss in Spanish, but it wasn't because we were focusing on LEP Latinos as a distinct group that had separate needs. We don't track necessarily LEP Latino versus Latinos that speak English. In fact, I think that would be inappropriate for us to start looking at last name. I think that would be somehow discriminatory. But as far as representation by attorneys, it's a low number across the board. The number of lawyers that represent consumers in debt collection is somewhat limited. The cases are small. The amounts at issue are relatively small in general. I think the average lawsuit is for about $4,500. We try not to sue cases that are too small because of the economics of the case themselves. But there are people that do represent consumers. I think we do find that there are more public law lawyers representing people with lower income. As opposed to breaking it down by LEP Latino, I think it would be more by income stratus. If you don't make a certain amount, you qualify for a public lawyer, as opposed to the lawyer saying that you would have to go to somebody that you would have to pay for.
Okay. Anyone else have thoughts about attorneys representing Latino and LEP consumers in debt collection litigation, and sort of where they come from, and could that be fostered in any way?
Well, I think Harvey's overall point is a very good one. As far as it goes, which is that very few people are represented. I think that's a bad thing. Across the board, it's not Latino or LEP Latino specific, and there's whatever we can do about that, we should do. outreach matters. At this point, and it was not always so, half of the people, of the clients that we see in debt collection cases are LEP Latino. That is not, it did not used to be that way before our clinic and the Immigrant Consumer Justice Clinic went into effect. So one thing you can do is to start practicing in the area and make it clear that your doors are open and you're looking and that you are available to help represent people. But I think Harvey's point's a very good one. Our income guidelines are pretty strict, and they're low. I mean, there's leaving even within those income guidelines, the vast majority of people are not getting representation, and outside, it is also a very small percentage of people who are represented.
My sense, I mean, there's not enough attorneys to go around, that work for public interest or nonprofit organizations to defend every debt collection client. It's supply and demand. The demand is great, and many of the demand don't even come, to let you know that they need assistance. But even those that are seeking assistance, can't. There's just not enough of us that do this kind of work. Because a nonprofit organization will do it for free, and if someone can't afford to get their own attorney, that's kind of their only choice, unless they can find a pro bono attorney, which sometimes nonprofits are able to connect them with a pro bono attorney. But there's just not enough attorneys out there that will take on those kind of matters.
And so, just to follow up, the sort of work that Allison is doing in San Diego, to the degree that can be scaled up, is very important. And to the degree, and there are groups around the country who are working on this, to the degree that there are materials independent of lawyers that can help people, and that those materials are being developed and tested, that's also a route to pursue.
Thank you. Well, let's turn to when a consumer actually ends up in court, whether it's a trial or at a hearing. I'd be interested in hearing from the panel members about any language barriers that come up for LEP consumers in the court systems with which they're familiar or in which they practice, and talk a bit about what kind of translation services are available, who pays for them, what is the quality of them, and the like.
So we practice in 3 states, Colorado, New Mexico, and California. I think Michaela has discussed what happens in Colorado. New Mexico has a significant amount of language access. Every court in New Mexico has a language access plan. They have translators in the courts. They are free translators. So in those 2 states, we're not seeing problems with translation for LEP Latinos. California is a little bit different. California happens to have the largest population of LEP Latinos in the country. LA County has the largest population of LEP Latinos in the state. And our court system in California does not have sufficient amount of translators. They are slowly, and this is part of the strategic plan. The plan is a 5-year plan. The intent of the plan is to have translators for all court cases by 2020, which is 5 years down the road. We have a court system that has a significant deficit. So where they're going to find money to fund a translator program is going to be very interesting, because right now we can't even keep our courts open. We don't have enough judges to hear the cases. There is a challenge with translators, though, and I found a recent article in the Las Vegas Review-Journal, and basically it was talking about Clark County and the fact that the translators, it says, interpreter pay threatens court system. And they are fighting now over whether translators will be paid $50 an hour or somewhere between $35 and $40 an hour. So it's a budgetary question as well. It's where do you find the funds to provide the translation services? And then in California, the question is, not only an LEP Latino, but I think the report recognized that there's something in the neighborhood of 217 distinct languages that have LEP issues. It's not just a Latino issue. There are over 200 separate language groups that they have to worry about translations for.
A number of folks have referred to the development of access plans, strategic plans. I know, for example, the Department of Justice Civil Rights Division has come up with a technical assistance tool that's designed to help court systems throughout the country develop language access plans. And there's one under development in California. My understanding is some other states have actually completed their plans. But one thing that I would like to ask some of our panelists who have been involved in the process of developing these plans through hearings, filing comments, and the like, what sort of topics are addressed by these plans, and are there any particular ideas that they have seen in the development of these plans that they think are particularly useful for policymakers in other jurisdictions to consider?
Well, when they're developing plans, the Department of Justice tool that you refer to is actually, it's specifically tailored to the court systems, and it provides some information, and it's really, if you take time to look at it, and you can download it, I believe it was released earlier this year, it breaks it down into different types of elements, like are there interpreter services being provided? Are there translation services being provided? What's the signage within the courthouses, and how are you communicating with them? How are you assessing the effectiveness? How are you recording information? These things are all important as far as they need this information, as Harvey was indicating, so that they can formulate budget plans, because budgeting is an issue for every state out there. I mean, court systems tend to be very costly to maintain, and especially if you're diversifying them and providing additional assistance. I believe for the 2015 year, Colorado has requested part of the judiciary's budget system. They're asking for an additional 7 full-time employees, and that's an expense just for language access. And so I think if for anybody who's out there looking at these tools, you need to understand the communities that you're serving, what type of communities and their specific needs are, and then how do you assess whether or not you're meeting those requirements, and how you communicate with the people who are utilizing the language access and getting the feedback. I know the Colorado interpreters, most of them are walking around now with iPads. It's really quite fun. And they're recording information. They're recording the case. They're recording how long they're providing interpreter services, even if they're full-time employees, the nature of the services that were provided. I mean, they're tracking a bunch of information so that it goes back into determining the budget.
I've just looked at the California plan. I haven't been directly involved, but it's pretty comprehensive, and I think it tries to take a realistic, hard look at, you know, what are the conditions on the ground, and where can we get to where we want to be. You know, recognizing that it's going to take some time to have enough certified court interpreters. It calls for developing standards to provisionally qualify somebody to be an interpreter, even though they haven't been fully certified. It also, you know, emphasizes the importance of recognizing when there are conflicts of interest with somebody who's not a court-certified interpreter, you know, like someone in court staff, if they try to interpret family members. It says, you know, in absolutely no circumstances should a minor child of a party to a lawsuit be an interpreter. That's just too much stress to put on someone's family member. It looks at the possibility of remote interpretation services and the pluses and minuses of that, but, you know, definitely says, you know, you should not, I think it comes out against, like, teleconferencing an interpreter, because you need to have some sort of face-to-face contact, and it says, well, even with remote video interpretation, there are some issues that should be looked at, but short of being able to have enough bodies in the courtrooms, that's, you know, that's another thing. So I encourage people to look at that. I think there are good ideas in there, and I think the 5-year plan is generally a good one. But it's, you know, what, again, it comes down to funding and whether there's going to be enough funding. Right now, the courts are all over the place, and, you know, my recent experiences, I've had some clients that I provided some sort of technical assistance because they were in small claims court, and you can't be represented directly by an attorney in small claims court. And, you know, there's no interpretation services available in some of these courts, just because of the budget shortage. So she's got to scramble to find somebody, either to pay somebody or, you know, bring a friend, and that's definitely not ideal at all, for all the reasons we've talked about. I was in a settlement conference the other day and with another client, and she brought a friend who's bilingual just in case. We didn't have time to hire anybody, and it's a pro bono case, so it would, you know, she wasn't going to pay for it. But the judge was pretty adamant. We did reach a settlement. The judge wanted to read the settlement on the record and have the client understand and agree to it. And he was adamant about, you know, putting everything on hold until they could scour the courtroom and find somebody, and that process took about 45 minutes. And finally, we got somebody to come and interpret. And he told her, I don't know if we're going to be able to find anybody, and your friend may just have to do. And that's not, again, that's not an ideal situation to have somebody, you know, agree to a settlement to on the record. So it's a big issue.
And it's also a question of priority. One of the things that we're looking at today is debt collection law. So the courts are faced with a bigger issue. The courts are faced with access to the court system for LEP Latinos for the entire court system. And that includes domestic violence, it includes divorce, it includes criminal, it includes landlord-tenant, it includes small claims. So what we're looking at is we're looking at a microcosm of a larger environment. We're looking micro versus macro. The court system has to look at it on a macro level, and they're prioritizing what areas they deem to be the most important as far as access to justice. And I think it's becoming very clear that the highest priorities are criminal defense and domestic violence.
Okay, maybe sort of to follow up on something that Joseph mentioned. You know, are there any technological fixes or partial fixes for the problems that we've been discussing that relate to Latinos or LEP consumers in the court system? Are there any things that we can do through new technologies or new applications of existing technologies that could be helpful in dealing with any of these problems? Anybody who'd like to speak to that?
Well, I can say when Colorado was developing their language access plan, and they were doing it in quite a hurry, they have a translation service that's located in the 18th Judicial District that is there to translate the language, and there's a huge demand, and they're trying to keep up. A lot of that information is getting emailed, faxed, scanned over in various ways, and they're having court-certified interpreters and translators, and there's a big difference in your qualification levels for doing those types of things, working very hard. In Boulder County, they also maintain a telephone system line. Then it's not just for Latinos, because a lot of our courts have on staff Spanish-speaking interpreters. But we also have over 200 languages that are requested for interpretation services throughout our court system. And that, if we can't get somebody for like Somali descent or something like that into the courthouse right away, and they need somebody for a short hearing just to make sure they understand a continuance is happening until we can get the interpreter physically there, they're using this telephone conference system. And there are technical issues that come with that, but it's all recorded online. You've got some information that's being provided by video. We've got one jurisdiction in the county court that actually plays a video before the parties are expected to communicate with one another directly, and it provides all self-represented litigants information both in English and in Spanish, and it's done by one of the judicial officers for the English version, and then a certified court interpreter for the Spanish version.
One of the things in the California plan is creation of multilingual standardized videos for certain types of cases that lend themselves to standardized types of information. So I think, debt collection is probably one of those areas, and it would be great to kind of take that and run with it and create something that the legal community from, all stakeholders and interests could agree on, could be shown to folks in Spanish and other languages about debt collection cases.
Well, and there actually is such an animal. On the Judicial Branch of California, the California Court website, there is a 5-chapter video called Resolving Debt Collection Cases. It is available in English, Spanish, and Vietnamese.
Right, and again, it's something that I think is, Michaela spoke about videos being shown in the court or, live, and I think that's something, because this particular community, many folks, again, don't have access to the internet or don't know how to use the internet. Many of my clients don't, and so I think there's a lot of great stuff on the web. FTC and CFPB have great information in Spanish on the web. And I think maybe the next step is to, take that information and find a way to get it on the ground, whether through videos or public service announcements on television, or other ways, because there is a large segment of this particular community, in any sort of non-English speaking or immigrant community that really, still do not, are not actively using the internet these days.
I've been using the videos, not those in particular, but when I do my presentation, I've started incorporating videos from the FTC's website, and I found them very useful. Makes my job a lot easier in regards to resources, and in regards to the information available at the California Court's website. Regarding, they have very useful information in regards to if you've been served with a summons and complaint, what issues you should consider. And I found that it's in Spanish and English. I don't know if it's in any other languages, but it's very useful as a legal aid attorney. It frees up some of my time.
So would it be fair to say the information's out there, it's just a question of how do you deliver the information to the people that need it?
It sounds like there is a lot of information out there on the internet, certainly. So, I think a big issue is how to deliver it on the ground, particularly for folks who don't have access to the internet.
And I think there's some questions about whether how complete the information is and how effective the information is as well. But there's some out there, and that needs to be evaluated. I know the California courts are looking at improving that website in particular.
I think with the information out there, if the clients don't just need to, the clients don't just need to receive the information, but they also need to be able to put it into context. And sometimes the information they find online, it's just one part of the collection process, and they may not be able to relate it to what they're necessarily dealing with, so they may not necessarily understand the significance of it.
Well, let's turn now to some of the questions from the audience that people have provided, and if people have more questions, certainly write them on a card and send them on up. And these are in no particular order. So, first question is, what steps have you taken to avoid the problem of sewer service? I guess that would be anyone who is filing a case against consumers. I guess maybe to frame it a different way, what do you do to make sure that service happens as it is legally required to happen?
That's a much better question.
I figured you'd like that better, yeah.
Sometimes I wonder about the questions where the answer is implied by the question. Let me be perfectly honest. Not only don't I approve of sewer service is a waste of my time, my effort, and my money. Because eventually, if I happen to have a bad service, somebody's going to call me up or write me a letter, and they're going to say, Harvey, this consumer lived 20 miles away at the time service was made. He wasn't receiving mail at that address or whatever the circumstances were. Vacate the judgment and start over again. From a practical standpoint, that's not good for me. I don't want to have a judgment that somebody can set aside. So we have a series of controls in place to try, and I repeat, try to ensure that we get effective service. First thing we're doing is we're scrubbing our files when they come in the door with the National Change of Address service. So we're checking the U.S. Postal Service to see if the address we have has been changed since the information was given to our client. We are sending out the 1692G initial notice to the consumer. If it bounces back, I'm going to put it in a skip tracing queue so I can find a better address. We're checking credit headers, so we're checking to see what the latest address is that's been reported to the credit reporting agencies. We have triggers in place, so if there's a change of address, if a consumer goes and makes an application for a loan, a new loan, and changes the address with credit bureaus, we're gonna be told that information. So we try to have valid service. The second thing we do is we have a control in place that after service to process is made, our service provider sends us a copy of the declaration before it is filed with the court. We are requiring GPS coordinates. We are requiring a full description of the person that's being served. We get age, we get height, we get weight, we get a description. We then validate certain data points against what we have in our system. I'll give you a good example. If the process server says I did personal service on Betty Jones, and the description is 31 years old, and some other qualifying features, and I look at 31 years old, and I look at my qualifying features, and I find out that Betty Smith is 75 years old. Not that I would necessarily sue somebody 75, but I don't age discriminate. But if they're serving somebody 32 years old, and I've got a 75-year-old consumer, and I can tell that from date of birth, I'm going to go back to my process server and I'm going to say, service is no good. Why do you think service is good? So it's not beneficial to me to have bad service. I don't stomach it. We do a lot of vetting with our process servers. We require certain data points from our process servers. We require a picture of where they were at the time. We have a checklist that we have to validate for the service to make sure that we believe, or we have a reasonable basis in fact, to believe that service was proper. Are we right 100% of the time? No. But we try, because a bad service is going to cause me problems down the road. We try to have 100%.
Let me just ask some of the folks who represent people on the consumer side, do you get complaints or concerns from the people you represent or the people with whom you interact about service problems?
Yes.
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 Let me explain. First of all, President Moore, long may you reign. I hope that this video will be shown to your members, and that the points in the Moore plan are implemented across the industry. It would be a fundamental change in what we've seen. And as people have pointed out, what we see is in many cases the people who have been harmed most seriously. Let me talk about just one practice that we have seen of late. Harvey talked about the problem of someone just saying, well, you're going to have to reopen the judgment, and then just sets it all back. Well, you have 2 years in California to reopen that default judgment, to vacate it. And we have recently been seeing wage garnishment orders served 2 years and 1 month after the default judgment was obtained, and it's much harder then to do anything about that judgment. So there are bad actors out there, and unfortunately we need to keep them in mind. There are a number of different steps that can be taken. The Moore plan is an excellent start. In New York City, they take the sewer service capital of the nation. They take the additional step, a simple step, of requiring the plaintiff, creditor, or debt collector to supply an envelope, a stamped envelope, and a copy of the summons and the complaint goes in there, and it is mailed, just mailed, to the defendant. And that simple step is one that we might, I think, consider in California as the budgetary situation improves, in particular the court budgetary situation improves.
Let me move on to another question. It's kind of an interesting one. The question is, do you believe the LEP community is reluctant to use legal aid due to the perception that free legal services may be less effective compared to services for which they pay a fee? What needs to be done to change this mindset amongst members of the LEP community? I'm curious as to if anyone thinks that that may be driving any of the decision-making here, a perception of relative effectiveness of counsel.
I'll speak to that a little bit. I don't know, if, at least for the LEP community, I don't think that's necessarily true. It is something that's been brought up before in different areas, but in regards to this community, no. I think the clients who come to us usually, well, at least because of the topic, debt collection, they're scared, and they go to a lot of different places for services, and usually they end up with us many times because they've been scammed, and usually someone, maybe a government agency said, go to this agency, BedZedek, Public Counsel, Neighborhood Legal Services, some of the agencies, at least in LA County. So at least in Los Angeles, many clients come to us after they've been scammed, after they've been going to a lot of different places, and then come to us because they realize this is most likely where they're going to get help that they can trust. So.
Let me ask another question. Someone had sent in, this panel is focused on litigation. Do panelists have experience with LEP Latinos in arbitration? And if so, are the same issues arising in arbitration as in litigation or not?
Well, actually, in Colorado, we do more mandated mediation, and because it's mandated by the courts, yes, we actually get the court's interpreters, the certified interpreters present to participate in the mediation services, and it's really helpful when that works, really helpful.
I think that would also be our experience. Arbitration or court-ordered arbitration is, it's a dual step, because you go to arbitration, you get your arbitration award, you still have to bring it back to court and get it entered as a enforceable judgment. Again, it's a time issue, and I think for the most part, most consumer attorneys would try to resolve the case prior, and I think that they're more likely to go to a judge for determination than an arbitrator.
I'm interested to know. I actually don't know the answer of how much debt collection is happening through arbitration in California right now. It used to be the case that the great majority was happening through the National Arbitration Forum, which collapsed in the face of an investigation into its thoroughgoing corruptness from the Minnesota AG and the San Francisco City Attorney's Office. And I think that's one of the driving forces behind the subsequent flood of small debt collection cases in Superior Court in California.
Another question that is posed is, in your practices, what is the most common type of debt that you see being collected from Latinos and LEP consumers?
Well, our practice is primarily original credit grantors in the credit card area. So we don't have the experience of the auto that's sold over and over and over again, or the affinity products, or things like that. So most of our practice is in the credit card industry, some auto deficiency.
I think from the industry perspective, it's going to be based on what your area of specialty is. I mean, there are medical service providers who focus only on doing medical debt. There are people who do auto loans or mortgages, student loans. They specialize in those types of things. So it's really going to be dependent on what the company's type of business arrangement is and what their model is that's going to depend on that.
I mean, we've seen a range. I don't think I haven't really surveyed sort of our intakes to really know, but it's been a range from credit card debt to student, loan debt to foreclosure scammers and debt that results from that, to non-recoverable, mortgage debt that shouldn't be recovered because there was a foreclosure. So it's been a wide range, and I can't really say that any one of them is jumping out at me at this time. It's pretty wide range.
I would say payday loans are becoming a big issue, not necessarily because there are more lawsuits, but because the collection efforts are much more aggressive and abusive, and I think it's definitely something that we'll be seeing a lot more of.
Well, I'm going to blend together 2 or 3 questions here I have, and these are all posed to Harvey and Michaela. And it's essentially, what do debt collection attorneys do to make sure that they have adequate support for their cases before they file them in court?
Okay. If I'm going to go to trial in California, I have to satisfy the judge that I have enough evidence to win my case. And that's going to be done in one of 2 ways. It's going to be by declaration. We have a procedure in California called CCP Section 98, which allows me to use a declaration in lieu of live testimony, as long as I give the other side the opportunity to subpoena the witness, subject to the information in the declaration, cross-examine. The other is by live testimony, and my clients do have witnesses that I fly out to trials. We spend a lot of money to prove up our cases. My clients take it very seriously. We have witnesses fly from all over the country. We have witnesses that are now based in California or Arizona or New Mexico. Some courts that we practice in allow telephonic witnesses. So we bring a motion that allows a witness to appear telephonically. But we have the documentary evidence. If it's available, we have the application. We have the last card member agreement that was effective at the time of charge-off. We have billing statements. We can establish where the billing statements were mailed to. We can establish the data points that the consumer provided when the credit was issued. Now, the older the card, and this is one of the issues that come up, the older the account, the less likely it is that there is a application still on file, because the banking rules did not require, and still don't require, an application for credit to be maintained more than, I believe, 2 years. And if the card was opened in 1989 and it goes in default in 2014, the odds are you're not going to have a signed application. But you have a pattern of usage, you have billing statements. Our practice is we have the evidence necessary to satisfy the burden of proof at time of trial to convince a judge to give me a judgment based on the legal standard that I have to satisfy at the time.
Well, I think there's something important that has to be mentioned in this particular ramification. As a licensed attorney, you're under an ethical obligation to ensure that any suit that you're filing on behalf of a client has merit. In Colorado and New Mexico, there are statutes that actually provide for sanctions for frivolous and groundless claims. And based on that, if you're a licensed attorney bringing these types of cases, you need to conduct a reasonable investigation into the lawsuit and the materials before you file the lawsuit in order to establish and satisfy your professional ethical obligations. It's also in your best interest of your client to always do that, because you have a particular, it's expensive to litigate. Regardless of where you're litigating and how much you're litigating over, the cost associated with litigation is important to keep in mind. And my clients are not going to be throwing away, and right now I'm in-house counsel, but previously my clients weren't throwing away money filing frivolous suits because they don't get them recovered. You have to be able to obtain the judgment, and you have to satisfy the judge. And in Colorado and New Mexico, there are specific elements that they are requiring before a judge will even consider granting you a judgment.
Again, would that Michaela's ethics were followed by the entire industry. We would not have had a robo-signing scandal on the level of the mortgage scandal that we had over on the credit card debt collection realm. For whatever reason, these folks did not take their ethical obligations as seriously as they should have, and we needed to build into the Fair Debt Buying Practices Act requirements that would enforce perhaps those sorts of basic standards that you didn't think you would have to actually spell out. And one of them is a private right of action. You can go after folks who are violating that standard. But the other piece is that you can have all the good law you want in the world, but it has to be enforced. And if all of these cases are in a world where, and there are certainly counties in California where this is still very much true, most cases are going, collection cases are going by default, there's no one on the other side.
One last question from the audience before I have a final question for the panel, and this is, I guess, to combine two questions here, which are almost identical. People wanted to know from Harvey and Michaela, basically, what percentage of the suits you file end up in default judgments?
It's funny you should ask. I was trying to figure that out this week. We actually ran some reports in anticipation of some metrics that we're running, because we look at these types of things. From what I can tell right now, it's under 50%. It's ranging somewhere between 45 and 50% of the suits that we file go by default judgment.
Michaela?
Well, again, as I indicated earlier, there's a difference between what's a default judgment and what's an acknowledgement of judgment. And the courts and our computer systems and everything that we track don't discriminate between an acknowledgement of judgment and a default judgment. We just call them first appearance judgments. Sometimes within the office we call them default judgments, even though they're acknowledgements of judgments. And it's going to depend on the county that you're in, it's going to depend on the jurisdiction and the nature of the debt in particular, and what type of lawsuit you're filing. I would say on average, on our first appearance judgments, we're ending up with probably between 60 and 70%, but that also includes a fair number of those are actually acknowledgements of judgments.
Okay. I'd like to finish up here by asking each of the panelists to identify one change that they would suggest that the CFPB or FTC consider doing that could make the litigation system better for Latino and LEP consumers. Also, if you'd like, feel free to offer any final thoughts, final rebuttals on anything else you've heard today or you'd like to raise. And why don't we start with Jose and go down the line.
I would say in regards to making sure clients are aware of their rights, the issue of information being in Spanish, which is already being done. I think as clients reach out to us, legal service providers, I think our role is to make sure that they understand that they have options, that they understand where they are in the collection process, and to the extent that we can work together with the FTC and other government agencies, it makes our resources that much greater, because we have limited resources. So in that regard, I think the issue of just making sure information is available in Spanish.
Thank you. Joseph?
And I'll add to Jose's point, I think CFPB and FTC can do public service announcements on television, radio, ethnic media, Spanish-speaking media. I think that's very important. Obviously, you'll need to develop the message, but as Jose said, people need to be aware of their rights, and one of the best ways to do it is through media. I think that's the best way to reach folks out there who otherwise might not know about their rights.
Great. Thank you. Ted?
I'll start with your second part, and then I'll finish on what you're actually asking for. Just on something that left in the air a little on the previous panel was, what does SB 233 have to say about the statute of limitations? After all, for debt buyers, there is an absolute bar on suits filed after the statute of limitations has passed. There are notice requirements drawn from actual past FTC cases that require a statement of that the statute of limitation has passed and we cannot sue you, or that's if it's older than 4 years, if it's older than 7 years, that we cannot and will not report this to a credit reporting agency. What can the FTC and the CFPB do broadly and then narrowly? Broadly, something that also came up in the prior panel, it is clear that there are particular scams targeting immigrant communities, LEP Latinos in particular, that result in debt collection. And that, you heard about it earlier, but this is really Rigo's grandma, that, you order this herbal product and you just wanted one, and then, well, lo and behold, somehow you've signed up for something they tell you that is ongoing, and that you have to pay them every month. And you say, no, that's not what I did, go away, and the next person who calls you is the debt collector. And they're trying to collect. And you say to the debt collector, I didn't. Why, just stop. And they say, well, I'm just a debt collector. You got to talk to the seller in the first place. So you go back to the seller, and the seller says, well, I don't know about that debt collector, but would you like to buy some more product? So that's a current client of ours. So just, you both have, well, all agencies here have jurisdiction to take on the scams that result in the debt collection, in the bad debt collection that we're talking about. And then finally, to actually answer your question, Tom, in your rulemaking, you might consider making it explicit under the Federal Fair Debt Collection Practices Act that it is illegal to make a threat, direct or indirect, based on the immigration status of the consumer.
Okay, thank you. Michaela?
That's a tough one to actually consider, because if you're looking at it in the context of litigation, which is the purpose of this particular panel, I don't want to tread on a co-equal branch of government's jurisdiction and purview here. So, I mean, just working with that other branch of government to have some more uniformity and guidelines. I mean, we're all happy to have very specific guidelines. I mean, you give us, if you want notices in a particular way written, give us that verbatim, please. We're happy to use that.
Okay, Harvey, the last word.
So I'm a little selfish, just a little. I heard a figure thrown out today that the CFPB has recovered approximately $5.1 billion. 5.71? 5.75 billion. So you asked what the CFPB could do to help LEP Latinos in the litigation process. There are, according to the study I have, which is the migration policy issue, 6,867,200 LEP Latinos in the state of California. I would love the CFPB to help the state of California fund its language access program so that we can get language access for the LEP Latinos in the California court system, because it certainly isn't going to come from the budgets we have.
Okay, well, thank you all very much for all of your insightful and thoughtful comments, and thanks to the audience for the excellent questions you submitted. I'd ask people to stay in their places, because we're going to do a switch and have another panel come up here and begin without a break in between, but I'd also like to ask everyone to give a round of applause to our panelists.